situation. In taking a look at the McCrary case, I feel sincerely that this case, and I have a copy of the case for Your Honor as well. This case really states more of our position, where I'll refer the court to page 34, or actually start off in the conclusion, and that's on 36 of the case. The case's conclusions basically lays out that there's no First Amendment right of access to pretrial discovery material. There's Florida statutory right of access to such material when it becomes a public record, but that statutory right must be balanced against the constitutional rights of a fair trial. And that's what we're talking about here. If these issues, if these side issues keep becoming a distraction and and may or have the possibility of affecting my client's right to a fair trial, then it must yield. The First Amendment must yield to that right of the defendant's right to a fair trial. Period. I understand the public's need to know. However, these are issues that are irrelevant and could jeopardize my client's right to a fair trial. You have, in case after case, specifically Shepard v. Maxwell, where it basically lays out that the trial court has an affirmative constitutional duty to minimize the effects of the pretrial publicity. And in Estes v. Texas, it basically characterized the right of a fair trial as the most fundamental right of all freedoms and must be preserved at all costs. And when we say all costs, Judge, I think what we're talking about here are issues that we really don't need to be sidetracked with, and they don't need to, and I realize the great challenge that we have with this case and the public's desire to know. But there comes a line, and there comes a limit, and there are boundaries. If law enforcement photographed her underwear drawer, that doesn't necessarily mean that the media has a right to go in there and start photographing it. Not necessarily that that's what is the situation in this case, but it's a parallel. You have irrelevant images that may or that at the very least were a year before this case even began, and things that really are private. They were never meant for the public to view. They have no probative value as far as evidence is concerned. And if so, I'm sure the state could correct me, or actually file or submit which images they feel that are of relevance, and which I think they did when they did the filtered photo bucket discovery CD. I think that's pretty much what that CD surrounds. You have a situation, Judge, where my client's right to a fair trial is in jeopardy. Your Honor could see these images. This is a very small sample of what's in there. And quite frankly, we are objecting to the release of these images. We feel under McCrary, and I would note something else. The Sentinel in their motion to intervene, they laid out that we must establish a three-pronged test. Well, that's not what the McCrary case says. In actual page 35 of the McCrary case, on the top right-hand corner, it clearly lays out that the factors set out in Lewis are relevant to a finding of cause and should be considered in determining whether public access to a judicial public record. Judge, we all learn in law school, should and may means you can. Shall means you must. This case goes on to lay out that the legislature, through the Florida Rules of Criminal Procedure, by way of which our motion lies, clearly lays out that the court, on its own initiative or on its own motion of counsel shall deny or partially restrict disclosures authorized by this rule if it finds there is a substantial risk to any person of physical harm, intimidation, bribery, economic reprisals, or unnecessary annoyance or embarrassment from disclosure. Quite frankly, Your Honor, you call the balls and strikes, but you also get to call what's fair and what's foul. And in this situation, taking things to this extreme is foul. And we would respectfully request the court not disclose those from the general photo bucket CD and only release those from the filtered version, or in which those that the state feels is relevant to their case, at which time I don't believe we're even going to have an issue. Thank you.
Mr. Manning, I don't know if you wanted to be heard or
Our 119 issues are handled by the Chief Assistant, Mr. Gross.
Go ahead.
Your Honor, for purpose of the record, my name is William C. Bose, Assistant State Attorney. Basically, Your Honor, I have a case that I think is somewhat illustrative, and if I can approach and give the court Times Publishing Company versus State of Florida, which is a fairly recent case. Basically lays out the law. It seems, well, first of all, and I know Your Honor is familiar with this, but I think it's really important that we remember again what a public record is. And by paraphrasing the statute, 119.011 sub, well, it's 11, basically, and it defines public records, and paraphrasing it, it's everything we receive in the course of business, unless there's an exemption. The court in the Times case basically lays out in black letter law that says once criminal investigative or intelligence information is disclosed by the state to a criminal defendant, that information becomes non-exempt public record subject to disclosure pursuant to statute on inspection of public records. The court goes on to talk about that there are some exceptions and that the defendant has the right to ask Your Honor to restrict disclosure of it if it's going to inhibit the defendant's right to a fair trial. But that only a non-party can ask you to not release something that would defame them or threaten their safety